WESN.
Good day and welcome to this week's episode of Strictly Legal on WESN Content Capital. I am your host, Rondell Dono, attorney at law, and once again, I'm happy to be here. I'm happy to bring the law and you. Of course, you can stream us on all major platforms, WESN-CC, as well as check our podcast, Strictly Legal with RondellDonoa.com. Of course, today is an exciting episode speaking about gender-based violence. Of course, I'm looking from the victim's perspective as well as the system, how the system can be reformed. And I have two noble guests with me in studio. But of course, before we get to that, we have our new segment, which is called Legal Lingo, where we decode legal jargon and bring clarity to complex terms. So let's begin. In today's episode, our legal term of focus is protection order. Well, a protection order, also known as a restraining order, is a legal order in the form of a document issued by a court to protect an individual from harassment or harm, particularly in cases of domestic or gender-based violence. It may prohibit the abusive party from contacting or approaching the victim in any form or fashion. So let's give an example. Let's imagine Sarah. Sarah, a young woman who has been experiencing harassment from her ex-partner, Mark. Despite her repeated requests from him to stop, Mark continues to show up uninvited at her home and send threatening messages. Now, feeling scared and vulnerable, Sarah decides to seek legal protection. So therefore, by obtaining a protection order, Sarah gains a sense of security and peace of mind knowing that the law is on her side, hopefully. Now, now that we've deciphered protection order, let's take a break and we'll be right back with more.
Knowing how to tell authentic is as easy as 1, 2, 3. Find it, match it, search it. Step 1. Find the style number on the tag. Step 2. Match the style number inside the jersey with the number on the tag. Step 3. Search it. A quick Google search of the style number will verify the jersey is authentic when the search results match the jersey being searched. Don't be fooled by counterfeit jerseys. Before you buy, remember to find it, match it, search it.
Fan Zone, 2 locations nationwide. Center City Mall, Chaguanas and Movietown, Port of Spain. Nationwide delivery available.
And welcome back. You are watching Strictly Legal on WESN Content Capital. And of course, as I said, we are about to start this episode, which is Reforming the System, Justice for Victims of Gender-Based Violence. And we have two guests in studio, and they are Ms. Danielle A. Jones, attorney at law, as well as Ms. Roberta Clark, who is an attorney at law, as well as a social justice activist. And before I bring them on set, I would like just to say a bit about them. Danielle A. Jones is no stranger to the Strictly Legal set. She's an attorney at law with over 15 years experience. She has a very rounded practice and specializes in criminal law, family law, and civil litigation. Danielle believes in voluntarism and offers her services at a number of civil society groups, namely WINAD, Living Waters, Trinidad and Tobago Coalition Against Domestic Violence, as well as Romantra. Danielle is presently the community lawyer at Wholeness and Justice, CAISO, where she legally advises and represents members of the LGBTQIA community who suffers human rights violations. Danielle is passionate about obtaining equality of treatment for all persons despite creed, sex, gender identity, sexual orientation, race, class, nationality, or disability. Welcome, Ms. Jones. And of course, we have next Ms. Roberta Clark. I mean, she's distinguished, of course, and she's an attorney at law. She indicates she's not practicing, but she's mostly a social justice activist and gender equality activist, of course. Now, she is a commissioner on the Inter-American Commission on Human Rights. She has led UN Women Regional Offices in East and Southern Africa, Asia, Pacific, the Caribbean, and Libya. Prior to her career at the United Nations, she practiced as a lawyer in Trinidad and Tobago. She has engaged in civil society and the national and international levels, including as the chair, executive committee, International Commission of Jurists, and the former president and current board member of the Coalition Against Domestic Violence, Trinidad and Tobago. And she's our neighbor. She's our Bajan sister. So welcome, 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 Ms. Clark.
Thank you, Ronald. I like to think of myself as from the Caribbean.
From the Caribbean.
Including from Trinidad.
Of course, so thank you guys for visiting our set. I mean, I'm indeed grateful, of course, particularly in light of the fact that this topic hits close to a number of persons' hearts, particularly because it's a recurring issue, domestic violence, more gender-based violence, as we state, because not only women are the ones who are victims, but of course, in some circumstances, we have men. So really and truly, this episode really is about understanding, one, gender-based violence, two, supporting victims and understanding the flaws and deficiencies in our system. So I want to start with you, Danielle, as you are a practicing attorney. Can you outline really the current laws in Trinidad and Tobago now regarding domestic violence? I know there were certain amendments, but really and truly as it applies to protection order, etc.
So the DV Act, we have one very comprehensive act from 1999 and it was amended in July 2020, making a number of changes to definitions, persons who could apply, certain enforcement proceedings and so that the persons who could apply now would be those in a domestic relationship. So that if you are your family, meaning any member of your family, grandparents, parents, siblings, cousins, whether you all are living together or living elsewhere, then we have persons who are not related by blood, but they share a household together. So you know in Trinidad and in the Caribbean, it's a fitia, somebody living upstairs, a family living in 2 apartments downstairs. Yeah. So even in those circumstances, it would qualify. Prior to the amendment, if it is you all shared separate communal spaces, you would not have qualified under members of the household. Now we have where the Children's Authority, social workers, any person of interest could apply on behalf of a child. So if you're just walking down the street and you see every day that this child is being beaten or left neglected, you as an interested person could come to the court and make an application that there's this child who's suffering some form of abuse by their parents or whoever is the person. And then we have guardians. So you know in Trinidad and the Caribbean, you have people who take a child and just leave them by for somebody, and that person took care of them and then unilaterally takes the child and then have the child somewhere else where they are not being fed and so, that person, though they are not blood or they don't have any legal orders, they could approach the court and say, hey, I want back the child or dependent that I cared for because I had local parentis, meaning that I was the person taking care of this child as though they were my own.
Okay, so therefore, in terms of the, as you said, the wide range of personnel that can apply for a protection order. Now, is a protection order easy to obtain?
It is easy to obtain, but you have to first know how to apply for it, right? So the person, you could go to any district court in the area that you live, but for those who live in Port of Spain area, it would be the family court. In Tobago, it would be the family court. And we now have the Princestown Family Court. You can make application, but you must fall within that particular catchment area.
And Ms. Clark, now in terms of the type of protection orders that are afforded to persons who apply, what type of protection orders, and in your experience, are usually ordered by the court?
Ronald, if you will allow me, I just want to go back with Daniel on who can apply, because I think there's a very important new category of the people in the dating relationship or people live in who have an intimate partnership, and of course visiting relationship exists before. So I think the dating relationship is a new component of a new feature of the new act. So people who are seeing each other, not living together, not necessarily visiting, not that degree of formalization of the union, they are also eligible to apply for protection orders regardless of sexual orientation. That's really the most important thing. Yes.
Because I know in our jurisdiction, the laws particularly protecting persons of let's say, same-sex cohabitation, it does not apply in terms of granting of reliefs if there are separation. But in terms of protection order, someone can apply regardless of whether they are heterosexual couples or same-sex couples, etc.
Well, there's a technicality, right? Okay. You have to, when you apply, say it's a dating relationship, right? It cannot be just, because cohabiting under the Act means heterosexual couples only. So when someone and also visiting. Yes. So when you are going, you must go under the specific definition, right? And I want to take back, as Roberta jogged my memory, before a visiting relationship would be, you have to be in that relationship for a year before you could apply. But we all know sometimes 2 months into a relationship, 2 weeks into a relationship, it becomes violent. So they took away that time sensitivity of how long the relationship must exist, so that even if you dated the person for a day, you could go and they become abusive, you could go and apply for a protection order. And it speaks about current dating as well as former dating. So you will fall your ex and they who get abusive, you could apply as well.
And basically, what is the typical duration, let's say, of a protection order when the court the court orders? Is it still 1 year?
No, it was always 3 years. It was always 3 years. So you go from a month to 3 years, right? And if you say you get 2 years and the person continues to be abusive, you could just go back to the court vary and go up to 3 years. And I think that 3 years is a sufficient amount of time to determine whether this person will no longer be abusive. And after that 3 years, if they become abusive, you're going to reapply.
But there are instances where the court would have granted an interim protection order for lesser time until the matter is recalled. Or let's say, for instance, if it's an ex parte application, the court will grant that interim protection order until the other party or the abused or the abuser appears before the court.
Yeah, so before the amendment, from 42 days, so you can get an extension on the interim order up until 42 days from the date of the application. But with the amendment, they have removed that. So it remains in place until the court makes a final order, determine it, withdraws it, or revokes it. So that you don't have to, every time the person apply, put a date and you have to come back. It's just in place, and unless, of course, the court says, I'm varying it, revoking it, or varying it to change the terms and conditions. So because the delay at the court is ridiculous, is in excess of 42 days, right?
Well, this is and this is my point. It's all well and good that we have we go through the process in textbook, but in reality there are issues where persons who apply for protection order, it takes a while for the other party to be served, to be summoned before the court, and therefore that delays the process and it delays, I mean, it puts them in harm.
But we did try to fix that in
They
this.
fixed it.
We did try to fix that. So if you are having that kind, now remember, protection order is supposed to be granted forthwith. You know, there's the time sensitiveness of the protection order process is paramount. So if you are finding that there's been a delay in service, not caused by the actions of the person who's applying, but because of maybe the service has not been effected, the court is delayed because of its long list, or the respondent is evading service, the court can grant an interim order as a holding pattern there. But I want to come back to something, if you all will allow me.
Sure.
Because you asked the question about what kinds of protection orders can be granted. And I think it's really important for your listeners to understand there are two ways to go here. There's a criminal route, and when we're talking about domestic violence, often we're talking about significant and serious physical assaults and sexual assaults, which are crimes. Crimes against children, crimes against adults who are experiencing that. These are crimes. So the first thing that we are saying here, as a member of the Coalition Against Domestic Violence, is the police have the first responsibility to treat domestic violence as a crime when it constitutes a crime. And and that means investigating, arresting, charging. So that process is almost independent of the victim, because the justice system has its own interest in prosecuting violence for the deterrent effect. So there's that part. And then there's the protection order part, which is very much dependent on what the applicant wants. So you have two ways to go, but it's important that people know that the police have a responsibility to act and in the appropriate case charge and prosecute.
No, I'm happy you say the police has a responsibility to act. But then in practice, we've seen instances where police are called, and this is no indictment on all police officers, but police are called to a scene of domestic violence, and then they basically indicate, well, there's a family matter. They will speak to whomever, let's say the abuser, and then they would advise the abused to file an action before the court, and then they would leave. Fully well knowing the threat that exists.
And that still happens today, but with the gender-based violence unit, and I wish I could clone certain officers from that section and send them out to all the police stations, because I have seen them assist the person in filing an application for protection order, because that is what the police could assist someone in filing a protection order, and they also charge them for the criminal matter. So that, yes, we still have the problem with the police, but thankfully 2020 was a good year. The amendment to the Act and the creating of that department, gender-based violence, now called Special Victims Unit, right? And I want to take you back to the service and whether the service. So the long time the court will wait until, well, they could get ex parte order, but remember that an ex parte order, meaning in the absence of the person, it would not take effect unless the person is served. But now, if it is that there's no service after the first hearing, the court is the court is directed to ask the registrar to file the document to say why, and then you could file via substituted service. The court could proceed in the person's app. There are a number of other reliefs rather than if the person is not served, you know?
Yes, and as we discuss in law enforcement, the role of law enforcement, now, is there any way that an aggrieved person can bring up a complaint, a complaint to whomever authority or sue the state for failure to respond?
I would say, yes, and Daniel will speak about that, but just even before that, it's very clear in the Domestic Violence Act that police have duties, and it is made explicit. They can enter and arrest without a warrant under certain circumstances where there's imminent danger or the harm has occurred already. But they also, and the Act is very clear, the police have a duty to respond to every complaint or report alleging domestic violence, and that's very clear. And then they also have to prove that they're doing that by also issuing a receipt that they've received the report. This is part of the accountability mechanism in the Act. Of course, whether or not the Act is being implemented in quite the way that we want it to be, I think is an open question. Very importantly, there is a specialized unit, which Daniel referred to, now a Special Victims Unit, generally speaking, which deals with domestic violence, but also child protection issues, for example. And so we see that there's definitely an intention and a change in the approach to policing, with domestic violence being treated with a certain seriousness. But of course, you have police all over Trinidad and Tobago, not necessarily in a specialized unit.
And
so
not really trained.
Not necessarily. And the accountability mechanisms are not necessarily as clear as they should be. But yes, certainly you can go to Police Complaints Authority. You can go to the Special Victims Unit. You can complain to the specialized unit. If you're not getting a good response, you can complain to Police Complaints Authority as well if you're not getting a response. And of course, you always have, but it's an expensive and maybe a difficult measure of filing a judicial review or constitutional motion if you think that the state has fallen down on its duty to protect, which the state does have a duty to protect.
By that time, the victim is probably 6 feet under, or
most times it's then. Most times it's then, unfortunately.
And we have seen. So therefore, it goes to the next point in terms of identifying what if inefficiencies or gaps exist at this moment within the current legal system. And what gaps or what inefficiencies basically hinders the ability to effectively protect victims of gender-based violence?
As an active attorney in court, not sufficient manpower, and that would be not sufficient judicial officers to deal with DV matters, not sufficient specialized courts to deal with DV matters. So like in the Arima, the Sangre Grande, San Fernando area, in addition to the DV list, they have their family list, and that petty civil, they have all these other lists, traffic, and so on. So that before the 9th court in Port of Saint was only DV matters. So that you find persons in the litigants in that area got a proper service, but then we back to now fighting up with a list, some court dealing with 4 lists at a time, and it's really unfair to the judicial officer. And then the social services unit, not enough probation officers, not enough social workers. So those are the 2 main issues. There's also another issue, which is not enough written judgments at the appellate level. So in order for me to come and direct a judicial officer in the magistracy to tell them, hey, you're doing this wrong, I have to then apply for the FTR for me to jump the hurdles. If he's not on the FTR is the recording of the thing, the oral decision. So if it's
for the layman,
yes,
for me,
right? yes, the FTR, yes,
oral decision, and then I'm not an attorney who was in that matter. I have to jump the red tape and see if I get some senior to get the oral judgment. It means to come to show the judicial officer where they went wrong.
While time is ticking for the victim.
Exactly. And then you also need to have accountability with judicial officers. Everybody does be blame-based the police. But what about our judicial officer? And I find that they mustn't take this personally, because I could say the same thing. There are judicial officers who execute the act perfectly without any issues, and then there are those who don't do it, and then some person has experienced a disservice. So therefore, and when you see the same appeals coming at the appellate level from the same judicial officer, you will continue to leave that judicial officer there. No, maybe that is not the area that they need to be on. Need to move them over to traffic court, move them over to criminal court. Don't leave them there, because they clearly do not understand what is domestic violence.
And Roberto,
just to add to that, I think there's also, so the question of the person power, do we have enough resources? You know, on average, over 9,000 applications for protection orders are made in this country annually. So that's a lot.
Yeah.
All right, so you have the manpower question. But I think I want to speak a little bit about the attitude, because people who I speak to who come to the Coalition Against Domestic Violence, some of them, not all of them, because some of them really get a very good experience, but they talk about the attitudes of the justice actors, including, I'm sorry, Danielle, lawyers.
Of course,
right?
I'm not taking that.
Who may not treat this matter with seriousness, who don't understand the threat. They don't understand the threat, the risk. And then the judicial officers themselves, who, because of their list is so long, they themselves may not treat the matter with the urgency that is required. So that sense of lack of sensitivity to what is happening, I would like to hear from Danielle whether or not she's seen that has changed over the years.
It has changed, because you see now we decide to do our own little training internally. So you have a crew of attorneys, and like with the coalition, we got attorneys to volunteer, and we will do training sessions with them to show them, okay, when you come to law school, unless you have the courtesy of going to somebody's office to teach you to be a lawyer, you don't get that. But when they come and they volunteer, we teach them how you go through a matter, how you prep a witness for court, because sometimes a witness can be truthful, but then if they're not prepared and nerves act up. They would appear to be as though they're lying. So that is one thing. But we need, with respect from the attorney perspective, we need attorneys who are willing to train persons who are coming to volunteer at these NGOs. And we need attorneys to volunteer at the NGOs, even if it's for a specific period. I'm not saying to do like me and be there forever, but you know, you need to do it, because I only know this work because, again, I only know the law. And then when I come and I go to Coalition and Roberta and all of them that there guide me through the social worker, the counselor, you really understand how emotional abuse paralyzes a survivor and why he or she remained there for so long, the duration.
That's the thing about sensitivity, right? Because you have to understand the dynamics, the causes, the consequences, and the dynamics around domestic violence. And if you don't do that, you're judging. You're often judging the victim.
Yes.
What is it?
Why she coming back?
Why she didn't go? Why she leave him?
And wasting police resources. Look, she come back with she man.
And after we go there, there's a lot of judgment because the dynamics are not understood. People stay because they're so fearful. They're, as you say, paralyzed with fear, also paralyzed with stigma. A lot of people stay silent because they don't want to be, they feel ashamed and stigmatized that they are experiencing that. So there's a lot of suffering in silence because they're also going to be judged. Why have you stayed there so long? And then there's the fear factor, which I think is a very legitimate thing. If I go to the police, if I go to the court, who is going to be securing me when he becomes aware that I have done that? And we know that the most dangerous time for a domestic violence victim is after they've taken that first step to get to justice. But how is that person covered by safety when they're doing that? That's not very clear.
But do they have the special victims units? Do they have safe houses for victims of protection?
Not enough, because remember, and then some safe houses cannot accommodate, if it's a woman with children, they don't accommodate all of that. So then people don't understand the financial aspect of it. If the perpetrator is the one who is the breadwinner and the person is a stay-at-home, they don't understand. Some judicial officers expect a woman who have been home for 24 years to just pick up herself and go back out on the market and get a job and pay for half education, medical, dental. It is not that simple. If you have never been in the workforce or you're out of it for 10 years, you have to be retrained if you're going to go there. And then you're going out there with your burden of being a victim/survivor. Come on, so that they don't even understand it. Just, oh, she should just find a work. It is not as simple as that. Then if it is you are living under your in-laws and you go and report their son, and you had to come back, they put the son out of the house that the in-laws built. Everybody around you looking at you like, how you could continue to live there and you can't afford an alternative accommodation.
So therefore the efficiencies is not only in the system of the legal system that is, but also with respect to other areas of protection for the victims. The culture.
There is a culture that we are all living in. That culture is changing, thanks for people like Danielle with their work and the organizations that work on this area. But there's been for a long time a culture of acceptance of masculine violence in the home, and also a culture of silence in women, so that they don't speak out or they suffer it. You know, you just manage on your that. You know, in my time as a practitioner, I have actually heard a judicial officer tell older couple, listen, can I spend 2 minutes on this anecdote because to tell you how things have changed. Maybe things have changed. This was an elderly couple in a court in South, and he had done some serious harm to her, including breaking her arm, breaking her nose. Not really serious physical harm. And when she had applied for the protection order, in the last words, as the magistrate was dispatching the case, the magistrate told the man, do not do this anymore. And then he turned to the woman with a lot of emotion in his tone, and he said, you, madam, and when you see your husband in the street, cross the road. That was his message to her.
Wow.
But I think things have changed a lot since then.
It has changed, but I would say that at the police station, my client went to make a report of abuse, and they say, a pretty woman like you taking that? Pray to Jesus and help him to change your husband's ways. Wow. What is that?
So that's the culture that we're trying to change.
And the culture of, this may sound controversial, but in terms of prayer, yes, prayer changes everything, but then in action, I mean, at the end of the day, faith without works is dead, right? It's nothing.
They miss that part in the Bible.
But the part of the faith,
yes,
which is a little difficult for us to now deconstruct here, because in a lot of religion, in the text or in the culture of the religion, the man is the head of the household.
Yeah.
The woman is to be submissive and subordinate to the man. So when they're telling you to pray, they're telling you to pray in that context.
Yeah.
You see, which of course we know is the root cause of domestic violence, this idea of superiority over, of men over women.
And then we're looking at now women are more independent, they are succeeding independently. And sometimes in certain homes, when bonds and unions are formed, and the woman is the breadwinner, the man feels emasculated, and then that creates issues. It creates a bigger issue of violence, because we've seen it.
He feels emasculated by the culture, because it's not necessarily by the person that he's living with, but because the culture expects him to do certain things. There was a study done in 2018 on Trinidad and Tobago, which tried to find the risk factors, and the number one risk factor was controlling behavior. Men who really bought into the patriarchal ideology that men are to be at the head, to be in charge, to be in control, to have power over others, that was one the most significant risk factor. So we do know that it has to do with gender relations and gender inequality, which is why we link gender equality to ending gender-based violence. The two things go together.
Gender equality.
You can't get to no gender-based violence if you continue to have gender inequality in society.
So it's legal as well as social issue, and I believe that the social issues, if it's not addressed, then we end up in the same problem that culminates and continues.
You have to do advocacy at a very early age. I would say from age 5. Both sexes, both gender, everything. It has to start from that early. Because look, when we look at Samuel Selvon's book, A Brighter Sun, Tiger is not a man unless you beat Urmila. That was in our book, and it is still applicable in 2024, because there are some boy children who are cultured into thinking that you have to be in charge, and if she give you a little back chat, I had to manners her and put her down. And some women believe their role is nurturing, stay home in the house, give up your career, wherever, not by choice, by force,
Yes. So now we see we have identified the problem. Now, in your opinion, either one of you can speak first. What reforms are urgently really needed in addressing the inefficiencies to better safeguard victims of gender-based violence?
What we have is quite a strong legal framework, and we have to remember the legal framework is in the Domestic Violence Act, but it's also in the Sexual Offences Act, it's in the Children's Act. Yes. All of those things address components of domestic violence. The question is, are these pieces of legislation being fully and robustly implemented? Where are the gaps in implementation? I think what we've been speaking about here are gaps in implementation, and the gaps in implementation may be caused by structural problems. Donia talked about lack of person power, lack of maybe the specialized victims units all over the country in the numbers that you want, inadequate levels of social services, you started off talking about justice for victims, but there's also justice for perpetrators in the sense that perpetrators must be held to account. But not only be held to account, also have access to a kind of intervention where they can reflect on what their behavior is so that they can stop it. Because, criminalizing is one way of stopping it, but also people need to understand what they're doing to stop it. So we also need the social services, we need the specialized in psychosocial interventions, we need safe houses. I think what we talk about is a comprehensive response, which brings together the justice sector, the social services, policing, security, and housing, and of course the education, because you're talking about prevention. Trinidad and Tobago does have, I think, more recently a national action plan, I think, which was adopted by the cabinet last year. So I think we have to think about what is the accountability for the implementation of that plan. Does the public know what's in the plan? Are there benchmarks for and indicators for achievement? How do we monitor what the state is doing to change institutional culture as well as popular culture?
Yeah, and I just wanted to add, in terms of the when the perpetrator, we can't focus on the survivor and not the perpetrator, because as an advocate, I have seen where the perpetrator got the help of social services and those persons went on to have a very fulfilling relationship years later, right? And that happened in 5 of my matters, and I'm sure it happened elsewhere, but because with the correct intervention at the right time. But if we don't have enough social workers, if we don't have enough persons at family services.
And that's a major gap, social services, because the court sometimes requires status reports or from social services.
Yes, yes, and social services in that particular matter, the husband he was only abusive because he was living with his parents. But when he moved out, he understood that your mother do not like your wife, you need to move and live separate. And that was the cause of domestic violence between them, because his mother come in to tell him something about his wife, and then he get vexed with the wife, and you know, so that if it wasn't for the social service intervention, he wouldn't know what is his duty as to his wife and his child. Moving away from your family, because sometimes your family is the toxic trait.
Yeah, I think one of the main things, though, coming back to criminal law, when crime has happened, the police have to treat it that way.
Yes.
We have so many incidents and tragedies where there has been enough evidence that this person is at great risk of killing someone, but the police are not acting with the due diligence that they should to contain that person, arrest them, and put them into some sort of program where they can reflect on what they're doing, rehabilitation, but also just to secure them so that they're not a threat to others. One of the things that this act has in it, which was a novel thing, was that when there's been a breach of a protection order, the magistrate can ask for a risk assessment as a condition of bail. Because you want to know, is this person lethal? Is this person in that mind space where they're going to go and do harm no matter what? And if you find the person that there's a high level of risk for the person perpetrating, and again perpetrating with a greater cruelty, then you have to keep that person, you don't grant bail. You keep that person contained.
But would you believe that that risk assessment is just on paper? Because I asked for that in a particular matter, and when they contacted the Special Victims Unit, there was nothing in place for the persons who had to do the risk assessment. So again, y'all there, this is the role that you need the police and children's authority and the social service arm, because the risk assessment is to be done by specific persons. Then we need to have the manpower to fill the department to do the risk assessment.
So implementation.
Yes.
Implementation.
Let's segue a bit from the reform, because you mentioned something about the breach of protection order. I mean, by law, once a party breaches the protection order, who it is against, the victim goes to the police, and the police ought to act.
Yes.
Many times we have seen where the police don't act. They will tell them, well, go back to court.
Yes.
So tell me whether this piece of paper sometimes Daniel, in your practice makes sense, or do you as an attorney, when a police turn away someone, do you have to now intervene by enforcing enforcing an arrest?
well, the piece of paper, a lot of people, it's just a piece of paper. That piece of paper saved real lives in Trinidad and Tobago and elsewhere. So, and to me, without the piece of paper, now you'll get inaction. But when you have a protection order, the police has changed most of them, you get them to come. But for those who don't come, the client has to come and tell somebody that I went to the police and nothing happened, and then I call. I had a
situation, and then I end up having to call the head of the gender-based violence unit, Miss Tegay.
She's the best.
Yes, I always tell her, Miss Tegay, shout out to you. And she literally activated and got one of her officers to do what is necessary. You know,
so
and
all of that has to be a practice in every police station.
But what will happen when Miss Guy Island goes on her knife little retirement? We need more Claire Guy Islands, more other officers, because a number of them are the unit that will.
Especially in community policing.
Yes, they do a good job. They do a good job.
So back to the reform level, I know that there was a discussion offset about electronic monitoring. Let's discuss that.
So electronic monitoring is available for people in relation to criminal matters, not not just protection orders through the civil process or the quasi-civil process. So they, under the relevant legislation, a person can be monitored electronically as a condition of bail in a breach of a protection order.
Yes.
But I don't know, Donnell, have you ever seen that used?
Not in any of my matters, and one particular I had a watching brief, and the complainant at the time, that was the request through the police prosecutor for electronic monitoring because it was that the person got stabbed, house burned down, killed the person, dog. And the judicial officer was like, no, I don't know anything about it. I've ordered him to stay away from the victim/survivor, because no, I don't like to use the word victim, but in court is virtual complainant, victim, survivor, for those who have overcome such a very traumatic experience. But so if we have these acts, the act is there, the law has, we have no problem with the law now.
So the law can apply to
those who are
to domestic violence cases
who are
once it's in breach
of the
because
order.
it now becomes a criminal.
It becomes
offense.
especially the gravity of the offense. So if it is that he stalked, and in that matter he stalked her, went to her apartment, set it on fire, stabbed her, killed the dog, why wouldn't you put him on electronic monitoring?
Yes.
Needs to be on electronic monitoring.
So this is something that we need to advocate further, because I have not seen or witnessed any case where electronic monitoring was ordered for breach of domestic violence, breach of a protection order rather.
And we need to take away the consent of the victim, so that with those things, because there was one where the magistrate was ready and able to put it in place, and the survivors find that the monitor, that she has to remember that it will go off when he comes within a particular rate. It was
WESN. WESN.
Kigali, Rwanda's capital. Spotless, safe and buzzing. A city of 1 million people.
Welcome to the country of 1,000 hills, a country with a surge of creative energy flowing through it.
In this programme, Arts 24 is going to show just how much Rwanda, with its population of 14 million, has transformed in the past 30 years since the genocide against the Tutsis. And we'll meet the artists rewriting its future.
Wise man once told me.
The energy in Kigali is palpable. I'm in the neighbourhood of Nyamirambo. It's a lively, creative hub with street food and a buzzing vibe. It's also home to many talented artists and musicians, such as Kaya Binchi.
How would I describe Rwanda today? Ambitious and visionary.
Kaya represents a new generation. Like more than 3/4 of Rwandans, she was born after the 1994 genocide against the Tutsis.
Yes, we are meant to leave. That's why.
I feel inspired by the energy that I see in the country, like with the people. They wake up every day and they have goal is to live and is to be better than they were, because I believe that we have a spirit where we know the worst. So, like, if anything, it has to be the best, and the courage really around that spirit.
Kaya is just back from a European and African tour. She's working on a project to commemorate her country's past. She sings in Kinyarwanda, one of the official languages of the country, alongside French and English. The song she performs for us is particularly poignant.
It's the same source we came from. Colors of our skin, beyond beliefs and races.
Color of Blood is inspired by my experience with so many different people from different places, but also it's pushed by the story of my country. When you kill somebody else, it's a person, they have their color is red. So for me, it was that symbol of what we have in common, but with the idea behind that we are all the same despite our differences.
From the buzzing streets of Nyamirambo to a Kigali music festival with a special performance from Kaya.
Rwanda is a new place that people are finding out about, and I feel like Kaya Bishi is one of the artists that will take us outside of Rwanda and further out to the west.
Kaya is a unifying force on Rwanda's growing music scene.
They actually have some nice sounds and really good artists right now.
There are a lot of young, talented artists who are versatile with their skills.
Music isn't the only growing creative industry here in Rwanda. I'm at the very first Kigali Triennale. It's an arts festival celebrating excellence in Africa from all over the continent.
200 artists are on the bill in more than 10 disciplines, with 60 shows from 25 countries.
Violence ou ruse? Or pour chaos, violence, la ruse, l'ordre et le chaos.
The opening show is Gamblers, a play by Dorsi Rugamba, the founder of the festival.
Répète!